Hello and welcome to the Minimum Competence episode for Wednesday, June 10th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, the Fed Circuit axes Purdue's OxyContin patents, Anti-Weaponization fund foes press for proof of demise, plus a SCOTUS realists rundown. Let's remember, equal justice under law is not merely a caption on the facade of the Supreme Court building. And read today's legal news. On this day in legal history, 1963, President John F. Kennedy signed the Equal Pay Act, the first federal statute aimed directly at sex-based wage discrimination. The law took the form of an amendment to the Fair Labor Standards Act of 1938, which meant that it slid into an existing enforcement framework run by the Wage and Hour Division of the Department of Labor, a deliberate choice that bypassed the need to build new institutional machinery and harnessed 30 years of FLSA case law and habits of compliance. The legal hook is the Act's equal pay for equal work command. Employers may not pay employees of one sex less than employees of the opposite sex for jobs requiring, quote, equal skill, effort, and responsibility, and which are performed under similar working conditions. Four affirmative defenses are written into the text: a seniority system, a merit system, a system measuring earnings by quantity or quality of production, or, quote, any other factor other than sex. And that fourth catch-all has done more work in litigation than the other three combined, shaping how courts evaluate market-based, education-based, and prior salary-based pay differentials even decades later. The wage gap at the moment Kennedy signed was about 59 cents on the dollar. 6 decades on, by the Bureau of Labor Statistics standard measure, it sits closer to 84 cents. That tells you something about how a clean, structurally well-designed statute can still leave a lot of work undone, because the gap is and always was about more than identical pairs of jobs at the same employer. The Equal Pay Act is not the whole story of American workplace equality law. Title VII of the Civil Rights Act of 1964, the Pregnancy Discrimination Act, the Lilly Ledbetter Fair Pay Act, and a long line of state law analogs do much of the modern enforcement work. But June 10th, 1963 is nonetheless the day Congress, with the president's signature, said for the first time that paying a woman less than a man for the same work was unlawful. Full stop. Everything that has followed in this corner of the law has been built on top of that sentence. The Federal Circuit on Monday affirmed a Delaware District Court judgment invalidating 4 Purdue pharma patents covering an abuse-deterrent, low-toxicity version of the opioid OxyContin, in a decision the patent bar has been waiting on for months. The case is Purdue Pharma LP v. Epic Pharma LLC. The patents covered Purdue's reformulation of OxyContin to make the pills crush-resistant and to reduce a manufacturing impurity. And the asserted innovation grew, the company said, out of its discovery of the source of a particular toxic impurity that had previously eluded chemists at competing labs. Purdue's argument on appeal was, in essence, that the discovery of the impurity source was itself non-obvious and that the resulting patents inherited that non-obviousness. The Federal Circuit said no. The panel held that the relevant obviousness inquiry asks whether the claimed reformulation, not the discovery that motivated it, would have been obvious to a person of ordinary skill in the art at the time of the invention, and that once the prior art is taken into account, the answer is yes. The practical consequence of the ruling is large. It opens the door wider for generic abuse-deterrent OxyContin alternatives and clarifies a doctrinal point pharmaceutical companies had been pressing on for years. A hard-won research insight does not on its own automatically save a patent from obviousness if the resulting product was within the prior art's reach. Purdue's options now are a rehearing petition at the Federal Circuit, a cert petition at the Supreme Court, which the company has already pursued in a related case last spring, or quiet acceptance. Expect a cert petition, expect the cert petition to be denied, watch the generic drug filings that follow. The plaintiffs in the Eastern District of Virginia lawsuit over the Trump administration's $1.8 billion so-called Anti-Weaponization fund, a story we covered earlier this week, went back to Judge Leonie Brinkema on Tuesday and asked for permission to conduct limited discovery into whether the Justice Department's recent representation that it would stop work on the fund is a real commitment or a litigation convenience. The plaintiff's problem is straightforward. Acting Attorney General Todd Blanche has filed papers saying the program is, quote, not going forward, but President Trump publicly described the fund last week as a great idea that many Republicans support, and the executive order that created the fund has not been formally rescinded. From a litigation strategy standpoint, the plaintiffs do not want to walk away from a live case on the strength of a DOJ filing, accept dismissal as moot, and then find out 3 months later that the fund has been quietly resurrected under a different name. Judge Brinkema has a hearing scheduled for Friday, June 12th on whether to extend the temporary restraining order into a preliminary injunction. The Tuesday filing teed up the broader mootness fight that will dominate Friday's hearing. When does a federal agency's promise to stop doing something actually deprive a court of jurisdiction to enjoin the underlying program? And what discovery, if any, is a plaintiff entitled to before that determination is made? The doctrine here, voluntary cessation, capable of repetition yet evading review, and the heavy burden the Supreme Court has placed on the party claiming mootness, favors the plaintiffs procedurally. Whether Brinkema agrees on Friday is the question to watch here. SCOTUS blog's excellent John Elwood walked through a useful relist roundup on Tuesday, and the 4 cases sitting in the relist pile are worth flagging, mostly because each of them touches a different load-bearing wall in federal practice. The first is a prolonged detention challenge to immigration custody under Section 1226C. The ACLU is asking the court to clarify that very long mandatory detention periods trigger procedural due process review under the Matthews v. Eldridge balancing test, picking up on the Second Circuit's willingness to do so. The second is Newberry v. Texas, a case where Texas itself has confessed error, a rare procedural posture in which the state agrees the defendant should win. And the question is what the court does when the parties on both sides ask for the same remedy. The third is Kion v. Florida, a Sixth Amendment challenge to the use of 6-person juries in serious felony cases on the theory that the historical understanding of jury in the founding era assumed 12, and that the court's mid-20th century cases approving 6-person juries were wrong on the originalist analysis. The fourth is Maxwell v. Thomas, a federal habeas case asking whether the First Step Act's halfway house and home confinement provisions are properly enforceable through 28 U.S.C. 2241 habeas petitions, an issue with a real circuit split. None of these have been granted yet. They are relists, which means at least one justice is interested, but the court has not yet decided whether to hear them. But the mix is the part to watch. It tells you what the justices are circling without committing to. Expect at least one of these to be granted before the term ends. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday, and until then, remember, justice without force is powerless. Force without justice is tyrannical.